You've been arrested for a DWI in New Hampshire. So what can you expect to happen going forward in terms of the court experience and schedule? When you've been arrested for a DWI in New Hampshire, you're brought to typically a police station or a state police barracks. There, once you are booked, you're going to be released by a bail commissioner. And that bail commissioner is brought down to the station or the barracks, and they set either a cash bail or a personal recognizance bail. Personal recognizance just means that you have promised to appear in court, and they release you based on that verbal promise to appear. Typically in New Hampshire, the first date before the court is going to be an arraignment date. That arraignment date is generally scheduled at least 3 to 6 weeks down the road from the time of your arrest. The most important date to be aware of and to be cognizant of with a DWI arrest in New Hampshire is that 30 days after your arrest, if there has been a chemical test, whether it's breath, blood, or urine, over the legal limit of 0.08, or you exercised your right to refuse a breath, blood, or urine test, a chemical test, that triggers an administrative process where your privileges or license are going to be revoked 30 days after your arrest, typically. So even though your arraignment date is scheduled 4 to 6 weeks down the road, you have an administrative hearing process that you want to make sure you secure an attorney for. If you wait more than 30 days after your arrest, you're going to miss the opportunity and lose the opportunity to go through the administrative hearing process, which is critically important, not only to challenging a potential 6-month to 2-year administrative suspension, but also in preparing for the trial. In my practice, I go through the administrative hearing on every single one of my DWIs for a number of reasons. One, obviously to challenge the suspension of the license, but just as importantly, I use it to prepare for the trial that's going to occur down the road before the district court. That arraignment date that's been scheduled 4 to 6 weeks down the road, when I am retained on a DWI matter in New Hampshire defending the person who's been arrested, I'm almost always going to waive that arraignment, meaning I file paperwork with the court notifying them that I am appearing for this person as their lawyer. I ask the court to enter a not guilty plea on their behalf and then to waive the formal arraignment. And that accomplishes two things. One, the not guilty plea is entered, and then the matter is scheduled for the next event before the district court. And more importantly, it saves a trip to the courthouse for both myself and my client, because typically the only thing that's going to happen in an arraignment is they're going to call your name and you're going to answer the complaint by saying not guilty, and we can accomplish that through the mail. The district courts now in New Hampshire most often, depending on which court you're in, but oftentimes we'll schedule it for a preliminary, the trial management conference, pretrial conference, sometimes what they call a morning trial date, and that's more of a screening event. And again, that's going to be probably another 4 to 6 weeks down the road from the arraignment, where you report to the court on issues of discovery, whether discovery has been completed, and whether the case is in fact ready for trial. And then, because every first offense in New Hampshire, if it's a non-aggravated DWI, is a bench trial, the court is going to specially assign that case for a specific date and time for the actual bench trial. And that's typically done in the afternoon, a 1 o'clock trial date before the Nashua, the Manchester, the Derry, the Salem District Court, the Hampton District Court, whichever it may be. And that is ultimately when the case is resolved at trial on the criminal charge of DWI.